we have a team model, and there are team models. You know, there are all kinds of team models, but the one that we primarily use here in Dallas, anyway, is we have one neutral mental health person, one neutral financial professional. So you got a lawyer for each party, the parties, a neutral mental health, and a neutral financial professional. And it's been very, very successful, and here's at least my thoughts on it. I think that model is engineered for conflict. There's well engineered for conflict, because here's what happens when you have a team model, whatever flavor it might be, where there's kind of his and hers helpers, whether they be mental health, professional, legal, what have you. And so you've got a his and her team. The analysis may get more sophisticated, but the conflict is still like this. You know, we got a his team, a her team, and maybe we're all being more sophisticated about how we discuss that, debate it, and all those sort of things, but the friction is still this. With the neutral people, with a neutral mental health person, a neutral financial person, many times what will happen is, like say if it's a financial issue that the people are in heavy conflict about, that neutral person will say, well, I tell you what, I got an idea. Why don't we do it this way? And both people go, what? That's the craziest idea I've ever seen. And so now they're going after the neutral, and they're beating him up or beating her up. That, you can't do it, and this is why. But he or she's turned the room. So now that we got them fighting that person, and whatever that is, it's better than this. All right? So we've turned the conflict away from each other and put it somewhere. And then sometimes you can work it out through that. Same thing with an emotional issue. Is, you know, they're going at it like this, and the neutral mental health will say something, and they'll turn it, what? And again, it diffuses that conflict a little bit. It's not the only way to do it, but it's my preferred way to do it. You know, for me, you know, collaborative law is an agreement, a written agreement that's signed. We're going to try to settle. We're going to use neutrals. It's what's in our Texas statute. If the case impasses or somebody quits, the collaborating lawyers are kicked out, and you have to go get separate litigating counsel. That's collaborative law. Everything after that is just artistry. You know, how you do it. But that's the big piece of it. And to me, this team business is a good bit of, if you can have artistry and engineering all in the same thing, is a good piece of that. As a lawyer, the most important thing is the quality of my client's life. And the quality of their lives, I think, going through the collaborative process versus contested litigation anyway, is dramatic. People have a fear of public speaking. You know, when they do these, what are you afraid of? Death, you know, drowning, public speaking. It's always at the top. Well, being in court or having your deposition taken or something like that is, you know, public speaking squared or cubed, because you risk public humiliation or being attacked in public. And in the collaborative process, that's not just not part of that. So their quality of life, the client's quality of life, the children's quality of life, I think in most cases is dramatically better than what's available to them in the other process. But wait, there's more. Quality of my life is better too, and on a number of different levels. One, on those days when I'm called to go to the courthouse, and I still go down there. Rarely do I feel constructive. I get a result, but probably personally, professionally, I'm at my most destructive self at that courtroom, because I'm either trying to destroy the other people's arguments at the very best of things, destroy their credibility. You can't attack without hurting something, and that's what's going on down there. And so I don't always come home feeling great from that. In the collaborative process, I feel like I'm being constructive, trying to solve a problem and in a constructive way, not trying to fix something by destroying something else. And so just that, and maybe that's that attitude adjustment somewhere in there, feels great. The schedule is better. People can't notice me or my client for a deposition or set a hearing right in the middle of our family's vacation or whatever it is. The stress is different. There's a lot of stress. It's different. I thought at first it was maybe going to be easier. It's not easier. And it's not easier in a wonderful way, because here I am late in my career, and I'm being challenged intellectually and being challenged learning things that I don't know how to do, learning more about how to work with people, learning more about negotiation, learning all these new things late in my career. And so that's challenging and fun and invigorating. But because we're in the collaborative process, and the goal is to keep people in the rooms, visiting, talking, communicating with each other while they're in conflict. Especially early on, that was incredibly uncomfortable for me, very, very stressful for me. And I've gotten more and more adept at being in that conflict. But it's still difficult. You're with the clients so much, and you're just with them more. You talk to them more. You feel more of their emotions because they're communicating with you about it. And that's different than the courtroom. The courtroom, certainly there's contact with the client. We learn about this, we do that. Here's how this is going to work. But then it's leave me alone so I can do my courtroom thing. So there's stress in both, but the stress is different. I feel, obviously, and here again, this is just me, but I feel so responsible for the outcomes in the litigation. And in the bigger picture, the sane picture, I suspect it has very, very little to do with me. It's the facts of the case. It's what the judge or the jury happened to see. And I have a role in that, but I don't think I win the case or I lose the case. But my ego will tell me that. And so there's a lot of pressure at that courtroom. And that's not probably the way to do it, but that's the way it feels to me. And in the collaborative process, I don't feel that same kind of pressure, but it's different. So it's still difficult work. But between those two kinds of pressures, as a personal choice, I'd take the collaborative model any day of the week. The clearinghouse for information about the collaborative process here in Texas is the Collaborative Law Institute of Texas's website. And it's www.collablawtexas.org.